You just landed at JFK. You've been a green card holder for 6 years. You've traveled internationally dozens of times before. You know the routine. But this time, it's different. The CBP officer at the booth doesn't just glance at your card. He sends you to secondary inspection. You sit in a holding room for 3 hours. They go through your phone without asking for your password. And then, they slide a form across the table. They tell you to sign it. That form, if you sign it, cancels your green card on the spot. This is not a hypothetical. This is happening at American airports right now, in 2026. And if you are a green card holder, whether you've had your status for 1 year or 20, you need to understand exactly what is going on, because the rules at the border have fundamentally changed. Not slightly adjusted, fundamentally changed. Today we are breaking down 3 major new CBP developments that every green card holder must know before they travel internationally. We're going to tell you what the rules actually are, what officers are doing at airports right now, what your legal rights are, and what exact steps you need to take to protect yourself. Because the people getting blindsided at the airport right now are not people who did something wrong. They are people who simply didn't know. So let's start from the beginning. Before we talk about the 3 rules, you need to understand the environment you are walking into when you land at an American airport in 2026. ICE detention numbers have hit a record high this year. Nearly 69,000 people are currently being held in immigration detention, a number that has never been reached before in American history. And here is the part that should concern every single green card holder watching this. According to official enforcement data, 92% of the growth in that detention number comes from immigrants with no criminal convictions, no felonies, no misdemeanors, no criminal record at all. These are people flagged for what officials call administrative violations. Things like spending too much time outside the United States, having a document inconsistency, or triggering secondary inspection at the airport for reasons they never fully understood. CBP officers are now operating under what legal experts are calling expanded vetting mandates, internal directives that require heightened scrutiny toward lawful permanent residents returning from international travel. Secondary inspection, which used to be a relatively uncommon experience for green card holders with no issues, is now significantly more common than it was 2 or 3 years ago. Immigration attorneys across the country are reporting that their green card holder clients are being pulled into secondary inspection at rates they have never seen before. This is the landscape. This is what you are walking into in 2026. And in this landscape, 3 specific CBP rules and enforcement changes are directly affecting green card holders at airports right now. Let's talk about the first one. Rule number 1 is the mandatory biometric collection requirement, which took effect on December 26, 2025. This is a formal rule change published in the Federal Register by the Department of Homeland Security, and it applies to every single non-US citizen, including every single green card holder, every single time they enter or exit the United States. Here is what this rule actually means. Starting December 26, 2025, U.S. Customs and Border Protection is required to collect facial biometrics from all non-citizens at airports, land ports, seaports, and every other authorized point of departure and entry. Not some non-citizens, all non-citizens, and not just when they arrive, when they leave as well. This is a massive expansion of what CBP was doing before. Previously, biometric collection was largely limited to arriving international air passengers at major airports, and it was part of programs with geographic restrictions and exemptions. Those restrictions are now completely gone. Here is the detail that affects many green card holders specifically. Children under the age of 14, previously exempt, are now subject to biometric collection. Adults over the age of 79, previously exempt, now subject to biometric collection. Diplomats and most Canadian visitors, previously exempt, now subject to biometric collection. Acting Executive Assistant Commissioner of the CBP Office of Field Operations, Diane Sabatino, stated officially that this rule marks a major milestone toward implementing the biometric entry and exit mandate and strengthening the security of the United States. The biometric data, which includes your photograph and can include fingerprints and iris scans, is matched through CBP's Traveler Verification Service against your existing travel documents and immigration records. If you are a U.S. citizen, you can opt out of the facial recognition scan and request a manual passport inspection. Green card holders and other non-citizens do not have that opt-out. What does this mean when you are actually at the airport? It means you will be photographed at exit and at entry. If there is any inconsistency between the biometric data collected and your immigration records, even a technical inconsistency, it can flag your file for additional scrutiny. And with the enforcement environment being what it is in 2026, additional scrutiny is not something you want. There is a second layer to this rule that is specifically critical for green card holders from certain countries. The U.S. Citizenship and Immigration Services is now conducting intensive reviews of green cards issued to citizens from 19 specific countries. Those countries are Afghanistan, Burma, also known as Myanmar, Chad, Republic of the Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, Yemen, Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, and Venezuela. If you were born in one of those 19 countries, USCIS is actively reviewing how your green card was approved and whether the vetting standards applied at the time meet current requirements. And when you travel, when you step off a plane and present your green card, officers have access to that flagged status in real time. This alone is reason enough to consult an immigration attorney before traveling internationally right now if you are from any of those countries. Now let's talk about rule number 2. And this is the one that is genuinely putting green card holders at risk of losing their status at the airport itself. Rule number 2 is the aggressive enforcement of what is legally called the abandonment doctrine, enforced through something called Form I-407, the record of abandonment of lawful permanent resident status. Form I-407 is not a new form. What is new is how aggressively CBP officers are using it in 2026, and the conditions under which they are now presenting it to green card holders at ports of entry. Here is what is happening. The National Immigration Law Center and immigration attorneys across the country are reporting that CBP is detaining green card holders at airports and encouraging them, sometimes pressuring them, to sign Form I-407. If you sign that form, you are voluntarily giving up your green card. Your lawful permanent resident status ends the moment your signature goes on that paper. And here's the single most legally important thing in this entire video. Signing Form I-407 is entirely voluntary. You are under absolutely no legal obligation to sign it. There are no automatic penalties for refusing, no fines, no negative legal consequences. The American Immigration Lawyers Association and immigration courts have confirmed this clearly. If you do not sign Form I-407, CBP cannot simply revoke your green card at the airport. They do not have that authority. Only an immigration judge, in a formal court proceeding, can make a final determination that you have abandoned your lawful permanent resident status. And the legal standard in court is extremely high. The government must prove abandonment by what the law calls clear, unequivocal, and convincing evidence. That burden must be met in front of a judge, not by an officer at an airport checkpoint. If you refuse to sign Form I-407, CBP is legally required to issue you what is called a notice to appear. That sends your case to immigration court, where you will have a hearing before a judge, where you can present evidence, where you can have legal representation, and where the government must meet that high legal standard. So what do you say if a CBP officer slides Form I-407 across the table? You say this calmly and clearly: I do not wish to sign Form I-407 and I request a hearing before an immigration judge. That is the sentence. Those exact words trigger your legal rights under federal immigration law. If the officer takes your green card as part of the process, you have the right to request an I-551 stamp in your passport, which serves as temporary proof of your permanent resident status. Now, the law allows CBP to question green card holders about whether they've abandoned their status if they've been outside the United States for longer than 180 days, that is 6 months, in a single continuous trip. If you've been outside the US for more than 1 year continuously, there is a legal presumption that you may have abandoned your status, and the burden shifts to you to rebut that. But here is what has dramatically changed in 2026. The 6-month threshold, which was historically applied with some flexibility as long as you could show continuing ties to the United States, is now being applied far more aggressively. Officers are looking at cumulative travel patterns, not just individual trips. They are asking detailed questions about where you live, where you work, where your family is, whether you've been filing U.S. taxes, what your U.S. bank account looks like, and why you were abroad for as long as you were. Even trips that fall just under the 6-month mark can trigger extended questioning if other factors raise concerns. What factors raise concerns? Having your primary residence abroad, having a family that lives mainly outside the United States, working primarily for a foreign employer, filing taxes only in a foreign country, having very few connections to the United States, no lease, no mortgage, no regular U.S. employer, no active American banking history. Legal experts are clear on this. The length of your trip is one factor, but it is not the only factor. Officers are trained to look at the totality of your circumstances. And in 2026, they are looking harder than they ever have before. If you are a green card holder who has been spending significant time outside the United States for any reason, family, business, medical care for a relative, you need to speak with an immigration attorney before you travel and before you come back. You need to understand where you stand, and you need to know what documents to have when you land. What documents do immigration attorneys recommend? U.S. tax returns from recent years, evidence of a U.S. address, a lease, a mortgage statement, utility bills, a U.S. bank account showing recent activity, evidence of employment with a U.S. company or U.S.-based income, documentation of family ties in the United States. These documents can make the difference between walking through customs in 10 minutes and sitting in secondary inspection for 4 hours with someone asking you to sign away your green card. Now let's get to rule number 3. And this is the one that has caught a lot of green card holders completely off guard, because it involves something most people think of as entirely personal and private. Rule number 3 is the aggressive use of electronic device searches at ports of entry. Here is the legal foundation. Under federal law and current CBP policy, all international travelers, including U.S. citizens, visa holders, and green card holders, are subject to inspection of their belongings when they enter the United States. CBP treats your phone, your laptop, your tablet, and the apps on those devices as part of your belongings. They have the legal authority to search those devices at the border without a warrant. In 2025, a lawful permanent resident filed a civil lawsuit in Washington, D.C., challenging CBP's electronic device search policy as unconstitutional. That case is still moving through the courts in 2026. But right now, today, CBP's authority to search your devices at the border remains fully in effect. Here is how this actually works when you arrive at an American airport. During secondary inspection, CBP officers can ask to look through your phone. They can review your emails. They can look at your social media accounts. They can examine your photos and your messages. They may ask whether you consent to the search. But here is the critical legal reality for green card holders. You cannot prevent them from searching your devices, even if you say you do not consent. They have the legal authority to conduct the search regardless. If they decide to retain your devices for more thorough examination, they can do that too. They may send your phone or laptop to a forensic team and return it to you at a later date. If CBP seizes your devices, immediately request a receipt, a written record confirming your devices were taken. This creates official documentation of the seizure. Why does this matter so much for green card holders specifically? because the information on your devices can be used to establish intent in an abandonment inquiry. If officers see that you have been primarily living your life in another country, that your communications are almost entirely with people abroad in a foreign language about a life that exists almost entirely outside the United States, that information can be used as evidence in a determination about whether you intend to maintain your U.S. residence. For green card holders who travel frequently or spend extended time abroad, what is on your phone is not just personal data. In the current enforcement environment, it is evidence. So let's bring all three of these rules together and talk about what they mean for you practically. The biometric rule means you will be photographed every time you enter or leave the United States. Your data will be matched against your immigration records. If you are from one of the 19 countries under intensified review, your green card may be flagged. Before traveling internationally, understand your status and consult an immigration attorney if there is any question. The abandonment enforcement means the 6-month threshold is real and is being enforced aggressively. If you have been outside the United States for more than 6 months, prepare your documentation before you fly home. Know what Form I-407 is. Know you have the absolute right to refuse to sign it. Know the sentence to say if it is presented to you. The electronic device search rule means CBP can search your phone, laptop, and tablet when you land. You cannot prevent it. If your devices are seized, request a receipt immediately. Be aware that your messages, emails, social media, and photos can be reviewed and can potentially be used in any inquiry into your immigration status. And there is one more thing every green card holder needs to understand about what is happening in 2026. Immigration attorneys are reporting a sharp increase in what is being called catch and revoke tactics. These are situations where officers use information gathered during secondary inspection about travel patterns, device content, document inconsistencies, to initiate green card challenge proceedings at the point of entry itself. In other words, the airport is no longer just a place where you show your card and walk through. For green card holders who fall into certain patterns, the airport is where enforcement begins. The American Immigration Council published a report in January 2026 describing the current detention and enforcement system as bigger, harsher, and less accountable than at any previous point in history. Immigration judges are seeing more cases involving green card holders with no criminal histories than they have in years. None of this means that having a green card is no longer meaningful. Lawful permanent residence is still one of the most significant immigration statuses you can hold in the United States. What it means is that in 2026, the protections of that status require you to actively know your rights at the airport and before you travel. So here is what every green card holder should do right now. If you are planning international travel, consult with an immigration attorney before you go. This is especially true if you have spent significant time outside the United States. If you are from one of the 19 countries under intensified USCIS review, if you have any criminal history, or if you have any pending immigration proceedings. Gather and carry documentation of your U.S. ties, tax returns, evidence of your U.S. address, evidence of employment or banking, family documentation. Know that Form I-407 is voluntary to sign, that you have the absolute right to refuse, and know the exact words to say if an officer presents it to you. Understand that your electronic devices can and may be searched at the border without your consent. If you are detained at secondary inspection, remain calm and be polite but firm. Ask to contact your consulate. Ask for access to an immigration attorney. These are rights you have under U.S. law. And if you are currently outside the United States and you've been abroad for more than 6 months, do not wait until you are standing at that airport checkpoint to think about this. Talk to an immigration attorney before you fly home. Understand your documentation. Understand your rights. Understand your options. Your green card represents years of your life, years of applications, interviews, waiting, and uncertainty. Protect it the same way you fought for it, with preparation, with knowledge, and with the understanding that your rights at that airport checkpoint are real, they are legal, and they belong to you. If this video helped you, Please share it with someone who holds a green card and travels internationally, because the people who need to hear this the most are often the ones who don't know to look for it.